Good morning and welcome to All Things Divorce Podcast. This is Launi Sheldon, the host of All Things Divorce Podcast. Today we have Kaine Fisher, who is an attorney in Arizona. Welcome, Kaine.
Hi, Launi.
A little bit about Kaine is after graduating from law school, he focuses practice on representing clients in high conflict, high asset family law matters. Mr. Fisher handles all domestic relations, family law matters, including divorce, legal separation, complex spousal maintenance, and business valuation matters, paternity, child custody, parenting time, child support, pre and post nuptial agreements. I hate post-nuptial agreements. I'm just going to, that's my part. He does modifications and grandparents' rights. Mr. Fisher also handles criminal matters. So I didn't know this about Kaine before I got the information on him. So I thought this is kind of neat and I want everyone to know this. But he does handle criminal matters, not limited to DUIs, extreme DUIs, aggravated DUIs, OUIs. What's an OUI?
Operating while intoxicating. It's like a boat. It's a boat charge if you're drunk on a boat.
Okay. Domestic violence, assault, criminal damage, disorderly conduct, drug offenses, theft, endangerment, civil and criminal speeding, reckless driving, underage drinking, other vehicular crimes, post-conviction relief, probation and parole violations, sentence modifications, and some sexual offenses. So he was selected in 2018 as Super Lawyer Southwest Rising Star, an honor reserved for those lawyers who exhibit excellence in practice, which he does. Additionally, he received a Client Distinction Award from the Martindale-Hubbell, which is also really nice. He was named one of the best 10 attorneys by the American Institute of Family Law attorneys. He was named best attorney to have on your side to end things. So that's good. I mean, sometimes stuff gets dragged out. And so if you want it ended, go to Kaine, he'll get it over with for you. So that was by Scottsdale Living. Mr. Fisher also authors articles for the Arizona Foothills magazine on divorce and custody related issues. So pick that up and look for him on there. And he currently serves as Maricopa County Superior Court Judge Pro Tem. I did that for a long time. And it's interesting, and maybe we'll talk about that a bit too.
Yeah, it's coming to an end. I think I'm on my 7th year.
Yeah, it's a lot. It's a lot. Wow. I did when I did mine, what made me sort of end it was I was covering a judge's calendar and there was a relocation case on it. And I hated it. You know, I know I could never be a judge. I thought I could do commissioner stuff, which is what I typically volunteer for. But I had to do a relocation case and it sucked. So I didn't like that at all. I didn't like any of the people involved. And I felt bad for the kids.
Easier to advocate, that's for sure. I don't
like 100%. I love advocating 100%. So anyway, in Kaine's free time, he enjoys spending quality time with his wife, Alexandra, and his children, Dylan, Landon, Camilla, and traveling, playing softball, and supporting the Ohio State Buckeyes. So as usual, Kaine, I just do this quick legal notice, right? So as usual, listening to this podcast does not create an attorney-client privilege between me or Kaine and yourself. Kaine and I are only licensed, I believe you're only licensed in Arizona, right?
Correct.
We're only licensed in Arizona. However, the information that you're going to receive today can probably be used in most jurisdictions. Just look up the laws and it'll give you information on how to go about doing things. So today we're going to talk about how to get assets before your decree is final, how to divide some of the assets. And also we're going to try and hit on how to value some of your assets. Sure. So welcome, Kaine.
Welcome. Thank you for having me.
Well, thank you for being here. I appreciate it. I know sometimes with you lawyers, since I'm not litigating anymore, it's super easy for me to find time here and there, but I know it's hard to get lawyers to be able to appear and give up an hour of their day. So I appreciate it.
My pleasure.
So, you know, one of the big things, at least when I was practicing, was, you know, sometimes there's a house, people just can't live together. But there's money that maybe one person controls. And oftentimes it's the man. So I'm going to use that. The man controls the money. The wife wants the heck out of the house. and she's got no money, and he's kind of keeping it all from her.
Right.
How do you get that before the final orders? What do you do?
Well, I mean, there's a few things that can be done. You've got two people living in the same house that presumably aren't getting along together. Some of the more uncommon ways that people go about it is to nest. Sometimes you have one of the parents leave the house for a week and one of the parents stays with the kids in the house, and then they flop the next week or whatever. Very uncommon. There's a tremendous lack of privacy involved in that situation.
I did that in my divorce.
I mean, it takes a special breed of people to be able to pull that off.
It's hard, but it's good for the kids.
It's great for the kids because it keeps their home base.
Right.
And, it disrupts them as little as possible. But again, you're coming in and out. There's no privacy. I mean, you're sharing another place too. So
right.
You can have your own personal life. I mean, you can, but it's a little touch and go. Aside from the nesting, there's cohabitation, which is, the parties decide that it's more cost efficient to stay living together in the same house. As you can imagine, that's, I would say, uncommon. It's a little bit more common lately. I see people really trying to do that. But I mean, you just got to prepare your client. If that's going to happen, there's going to be stuff that comes up. You're going to have to set some ground rules. You've got to have rules as to, who sleeps in which room, privacy rules, all of those sorts of things to try to reduce conflict. I mean, because if you're going to cohabitate, you don't want to be exposing the kids to conflict and having this crazy situation where your attorney fee bill is going up because you're calling your lawyer every day about some new issue that arose, changing passwords on the Wi-Fi and just all kinds of crazy stuff. I mean, you guys aren't getting along, you're getting divorced for a reason, to try to live together as roommates. I mean, it's really no different. So again, sometimes, and I do find that when people pull that off, I mean, it saves the community a lot of money. It takes off the table sometimes issues of temporary child support, temporary spousal maintenance, because you're kind of, you're living together. So those obligations really aren't triggered, as long as the spouse's reasonable needs are being met and the status quo is being maintained. But again, it's so hard to find people that are capable of doing that. And so then, okay, we can't nest for whatever reason. We don't have the money to get this other place set up or whatever, or I just don't like the idea, or I don't want to be sharing a place with my soon-to-be ex-spouse. Fine, nesting doesn't work. Cohabitation doesn't work. We don't get along. I can't do it. The possibility for domestic violence, and I'm really sensitive to that. I've done a lot of work with domestic violence shelters. I'm a big advocate of fighting against domestic violence, and it's a big thing for me. So I always am coaching my clients and educating them about, listen, you're going to cohabitate. This is dangerous potentially. And, I send over a nasty letter or a firm letter about something, and you come home from work and your husband's there, he's been drinking or whatever. And again, not to gender stereotype, but this is a bad situation and you got kids there. Why do that to yourself? Okay, fine. Cohabitation doesn't work. Well, what do we do now? Something's got to give, right? And you could play this game, assuming you both own the house, of changing the locks. I really try to encourage clients to avoid that gamesmanship or gamespersonship. I just think it's silly. But you could play that tug of war to try to lock the other person out, but that really doesn't accomplish anything. So one option would be to resolve this conflict about who's staying in is get an order of protection. That's a really quick and easy way to get one of the spouses out. Now, look, I know there's some attorneys out there, I'm not one of them, that kind of manufactures these situations of domestic violence in order to get the order of protection, in order to get the spouse out. I mean, that's fine if you can get the order of protection and it gets upheld, more power to you. But there's this kind of backlash that happens. I mean, you're starting your case off on a very aggressive note, and it's going to really drive a wedge. Fees are going to be exacerbated throughout the whole case, guaranteed. The order of protection is always going to be used as a way to, well, I can't talk to you, so we can't communicate about exchanges. And it just creates all of this difficulty. However, there are certain cases, obviously, that an order of protection is absolutely justified. And that's step one. Let's get it filed with the initial petition. or close to it. Let's get him served or her served, and let's get him out. Then there's no question there. The person is out. They've got 15 minutes to get their stuff. They got to go find another place to live, go stay with friends, sleep on a couch, whatever you got to do, your problem, not mine. You shouldn't have hit me, or you shouldn't have, abused me or harassed me or stalked me or whatever. So that's one option, one to take very seriously. And then another option is, look, I mean, you filed for divorce, and I have some cases that last 2 years. That's not the norm, but literally 2 years of litigation, if not more. Most of them are less, but I mean, on average, I'm telling clients 9 months to a year from when you file, you're going to have your decree, if you're lucky. That 61-day lodge decree is a pipe dream. And what I mean by that is, you've got to wait this 60-day cooling off period in Arizona to finalize your divorce. So, you can negotiate, draft a decree, sign it, and then on day 61, you lodge it. About a week later, the judge signs it, you're divorced, yay. I mean, people come in and they're like, I want that. And like, as does everyone, but some cases are just way too complicated or too high conflict for that to happen. So realistically, 9 months to a year of litigation. And you may say, oh my gosh, how can I live with this a-hole for 9 months to a year? It's just impossible. And we're not getting along, we're arguing or whatever, but there really isn't enough for an order of protection. What do we do? And this happens a lot. I mean, and what we do is we file a motion for temporary orders. And it's a motion that you file. Some people think it's the magic wand, but it's really not, because you file the motion, about a month and a half later, you get a hearing, and it's not your evidentiary hearing, it's the hearing to discuss when to set the hearing on the motion for temporary orders. That hearing then takes place another 30 to 45 days, it's supposed to be 30, but sometimes the court sets it 45 days out. So you're looking at 2 to 3 months is what I tell clients. Like, you're going to have to figure it out. You're going to have to figure out how to live together until we can get into court on this Band-Aid motion, is what I like to call it. It's Band-Aids, right? So, and a lot of people are like, well, I don't have the money. And then I'm like, okay, well, if you want to force a spouse out and you're not the high wage earner, then now that stimulates this argument of temporary maintenance. Do you need some temporary support, child support, maintenance, to help, sustain your needs and pay your bills or whatever? Or, also, if you're trying to oust the spouse that is the primary wage earner, then, if you're trying to oust the spouse and you are if you're out and you don't have the money, then that's going to stimulate you to file a motion for temporary orders to try to get some support. So there's all kinds of issues that kind of stem from this consideration. And it's always important to kind of discuss those with your client, because you don't want to say, oh, yeah, let's get them out. It's as easy as that. And then the other side's asking for temporary spousal maintenance. And they're like, why the hell didn't you tell me that? Why didn't you tell me that I was going to have to start paying? So
yeah, that's another interesting thing, because when one party is out of the house, and the other party's got to figure out what to do, there's also sometimes we have these issues with cars that all of a sudden somebody's going to go steal someone's car that they've been driving the entire time, but now, they want it, or they need it or whatever. So temporary orders can be really great for a lot of things. They can be great for the house. They can be great for the cars. They can be great for temporary income, but they can also get some money, right? Like if you have some accounts with some big money, and or there are some accounts with some big money, but maybe you're not the person that can access them.
Yeah.
What does that look like?
Well, I mean, there's a statute directly on point about kind of what we call a pre-division of liquid assets. I mean, it's right on point here, to where if there's liquid assets sitting in an account, and let's say perhaps one spouse doesn't have equal access to those funds, you can go in and ask the court to divide that early and say, hey,
right,
look, there's $150,000 in this account. I've been cut off. I've been removed from the credit cards. I have no money to pay my lawyer. I can't pay my bills, XYZ. Then you can ask that money be divided and given to you, at least half of it or whatever. And then sometimes, we we liquidate the whole thing, and or we restrict some of it and then divide the rest. Or I mean, there's all kinds of other options with that. But to answer your question, yeah, I mean, there's all kinds of mechanisms that can be used to kind of loosen up money so that the spouses have that at their disposal. And then you mentioned cars. I mean, I see this a lot recently where you have either a premarital agreement or there's a sole and separate vehicle that the other spouse is using, but you have your own car and you're like, hey, I want to just go grab that car and sell it or whatever. I mean, I see that a lot. And granted, it's your sole and separate property, arguably, and you can do with that what you want to do. I mean, you don't have to. It's not in violation of a preliminary injunction to sell your sole and separate assets, even while the divorce is pending. But then we have to have this conversation about that's kind of a bad look. Also, are there kids involved? Does that parent need transportation to get the kid to school and whatever? And it's just kind of a bad look. So, but yeah, there's all these band-aids that we can put on when there's disputes about, a tug of war about certain assets.
And that brings up a good point, because just because you can do something doesn't mean you should do something. And I think, at least in Arizona, our judges have so much discretion over, division of assets, over parenting time. And if you don't want to get like spousal maintenance, child support, like all of these things, the judge has discretion on, and you don't want to piss off the judge, right? I mean, you don't want to go in there for the temporary orders and set the stage to piss off the judge for the entire length of your litigation.
This is you just nailed it. I think that what you just touched on right there is the quintessential kind of distinction between baby lawyers and experienced lawyers, or even good experienced lawyers and bad experienced lawyers. I think being able to master the ability to kind of give your client the information, but then persuade them in the right direction to do the right thing, I think is just that's what makes the difference in having a good lawyer. And a lot of times, I can't even tell you daily, I'm saying, here are your options. Here's what I think you should do. And here's why. And a lot of times it's like, well, a client will call me after 2 years. Well, there's this thing in my parenting plan that says that he shouldn't disparage me or whatever, or just some minor thing. And I'm like, look, I mean, yeah, technically you could go in and file a petition to enforce, but let's talk about cost. Let's talk about remedy. Like, what's the court going to do? Like, okay, bad dad or whatever. And is it really worth it? Does it make a difference? Does it create more conflict? I mean, so this happens constantly. And I just wish more lawyers were better at doing that. I mean, there are times when I just had this recently. I'd ask for a continuance. I recently entered my appearance. It was a resolution management conference, which, if you don't know, is a 10 or 15-minute hearing, status conference, whatever. There's really no prejudice ever if those things are bumped down the road a little bit. I entered my appearance. I had a conflict. I was on vacation. I reach out to the lawyer and I'm like, hey, look, I've got a conflict. I'm out of the country. And he goes, well, my client doesn't agree to the continuance. And I'm like, that's kind of your call, bud. Like, or it's at minimum your responsibility to talk to your client and be like, hey, look, they're asking for a continuance. There's a good reason for it. The court's likely going to grant it. Let's just agree. Nope, that didn't happen. I filed the motion, and literally 5 minutes after I filed the motion, the court grants it. And I put in the motion, and that, basically the other side didn't agree and didn't give a good reason. And it's like, where was the lawyering there? Where?
Yeah, I think that's one issue that we often have is client control, or dealing with someone else's lack of client control.
Yes.
We could do a whole podcast on that, because it's
I didn't
terrible.
mean to go down that rabbit hole, but
no, it's true. We definitely do a whole podcast on that. So what about, like, look, if someone is I'm going to do stereotypes in this just because it's easier for me to do. But let's say a husband has moved out, but has taken control, has all the control of the money, and you're not getting into court for 3 months. But he's also not paying the electric. He's also not paying the phone. He's also not paying the cable. And you've had a stay-at-home mom the entire time who has zero access anything? Can she start selling off the furniture in the house and selling off personal property?
Well, I'll give you my kind of canned, depends, or yes, but I mean, look, the preliminary injunction has always been this kind of amorphous, vague thing concept for me. You know, can you cancel life insurance? I don't, you know, or you know, it's unclear, and you really have to be careful advising your clients, because if you violate that preliminary injunction, it's contempt, and there's serious consequences, or could be serious consequences for violating it. So you always have to be very careful. But based on the facts that you gave me, the you know, with regard to your sole and separate property, you can do with it what you please. Now, if the other side finds out and has maybe some equitable lien claim against it, or there's some reimbursement claim, or there's some good faith reason why they want to stop a sale of some sole and separate property, they can file a motion and you can have a hearing on it, and it could be decided. But generally, a person can do with their sole and separate property what they want. What you're talking about, I think, is community property, community assets. That's different. I mean, what is clear from the preliminary injunction is you can't sell, dispose, conceal, hide, stow away, give away, you know, any community property unless it's, you know, to pay for necessities or to pay your lawyer or in the ordinary course of business.
Right. And I think that you could in this case.
I agree.
Where you've got somebody who's got, you know, where they've got to keep the air on. And I don't think a judge is going to go, first of all, the judge is already going to be pissed at the person who's putting their kids in a situation, or their ex, or possibly their kids, in a situation with no utilities, no food, and nothing like that. So I think that's already an issue.
Necessities are food, shelter, clothing, and electric bills is part of the shelter. So
right. What about selling the house? How do you get that done before? I know it's hard, and I know I just think of right now how sort of prices are going down, and you might want to sell it sooner rather than later. And if the other side doesn't agree, what can you do for that?
yeah, I mean, like you pointed out, I mean, let's assume it's a community residence, so you can't sell it unilaterally, and nor probably could you anyway, because no realtor is going to, you know, list the house with just one of the parties signing the listing agreement. But, you know, it's community property. You got to get a court order, or the other side has to agree to sell it. And it's funny that you bring this up, because this is happening a lot these last 4 months. Like, people are antsy to get it sold, you know, and you know, if you weren't getting divorced, I mean, you know, yeah, when the values were high, you didn't want to sell because then you had to go find another place to live. But in a divorce situation, when you know the house is going to be disposed of somehow anyway, it's like, oh man, are we going to wait 9 months for the market to go back down? Who knows? Are the interest rates going to go back up? Like, let's sell it, get our money, get locked into another house before the rates go up and before the market rebounds or whatever. So people are really antsy to get it sold because it is dropping a little bit. And so, I mean, it can be the request to list and sell, you know, if the other side doesn't agree, can be done in the context of a motion for temporary orders. If you're filing that, you know, for other reasons, you would just maybe piggyback that issue on top of it, or you could do a separate standalone motion to list and sell the property. And if you've got a compelling reason, and perhaps maybe you want to get a realtor in there as your expert to kind of lay out why it may make sense to sell now as opposed to wait. You know, and the thing about this is look, if neither party is going to do a buyout, let's sell it now. And look, if there's going to be a fight about the equity, then restrict it. Put it in a restricted account until you guys can get the mediation or a trial and resolve the other equalization claims. So
yeah, that's true. They can keep it in an escrow account, maybe give each party some amount of money to live off of, but
sure,
maybe hold back $100,000 or so for outstanding debt or attorney fees or whatever.
Or whatever. Yeah, for sure.
And can you also do that? Can you also divide the retirement funds early?
I mean, there's nothing that says that you can't. It's pretty uncommon. One thing I've gotten better at as I've been practicing longer is, you know, let's say you have a 401k, which requires a quadro, qualified domestic relations order, to divide it. when I was younger, earlier in my practice, we would sign a decree, and in the decree, we would talk about this whole process, this whole quadro process. Hey, look, we're going to punt it to a quadro person after the decree's entered, and they're going to figure it out. I don't do that anymore for the most part. Now what I'm doing is I'm getting that quadro attorney involved early and getting them up to speed. So that way, perhaps maybe we even submit the quadro with the final decree. But to answer your question, I mean, there's nothing that prevents the parties from agreeing to go ahead and divide that stuff. As far as I know, I mean, it's just pretty uncommon. And then even more uncommon is this situation of trying to ask the court to order an early division of a retirement benefit. I mean, I guess I see a situation where it might make sense, but when you're forcing a liquidation of an asset that could generate some tax consequences and penalties potentially, because you're not rolling it over via quadro and it's sitting there penalty tax free until the triggering event happens 10 years from now. What you're doing is what I think you're asking is the person is trying to like liquidate it.
Right.
That is going to generate tax, and that is going to generate potentially a penalty that then has to be sorted out.
Yeah. One of the things I always tell my client, or at least did tell my clients when I was litigating, is look, we can do all this stuff, but getting the court to address it in the long run, like at the end, all of a sudden, when you start doing this stuff gets lost. Stuff gets lost, reimbursements get lost, the tax penalties get lost. And it doesn't matter how great your pre-hearing statement is and how great how much you tell the judge, you could be going back 10 times after the decree, just trying to sort out the stuff that got lost in your 3-hour, trial that should have taken, 6 hours.
Yeah. I cannot wrap my head around how many times I've had to go to trial, and there's just like 10 issues where I'm like, how are we not able to resolve this? How is that attorney not able to talk to their client in 2 seconds and just send me an email and say, oh yeah, we agree? And some of it's part of the strategy. They try to just like have so many of these little things. They know that you're not going to have time to deal with them, and they hope that you're going to forget about them, or they hope that the judge forgets to address it. And it's just mind numbing because some of it's so basic and trivial.
Well, and also in like mediations, all of a sudden you give up that stuff, right? So you go to a mediation and you get everything resolved, and then they say, oh, there's this tax issue with the 401k that we split. They're like, well, we're not going to talk about that now. Let's just wash that. That's a wash. Yep. And all of a sudden you've lost, $10,000, $20,000 because of tax issues or penalties. And it just gets swept under the rug, sort of like attorney fees when you mediate like that.
I agree. But I mean, look, as long as your clients understand and they're okay with it, great.
Yeah, that's true. So what about, but liquid assets? Let's say somebody just has the control over the liquid assets. You can get that done in the temporary orders, right?
For sure. Yeah, I mean, there's no question about that, especially if there's been some conduct on the other spouse's part to try to cut off any source of income for attorney's fees. I mean, that's pretty common, right? Especially, not to gender stereotype, but
right.
Men, they, divorce, even if they're the one that fought for the divorce, and they cut off all access to the accounts because they're trying to theoretically strangle out the other party's ability to pay for a lawyer. And that's a big one. This happens so much. And this is the hardest part of my job when I have a client that comes to me who is a good mom, maybe a stay-at-home mom. There's significant assets, yet the husband has cut her off from everything. No access to any liquid funds, can't get a credit card, has no family that can loan money. And they're like, help me. And I'm like, oh, maybe the guy's a drunk, or there's parental fitness issues. There's, unscrupulous conduct. Like I found an account in the Caymans, or like, so there's all this good stuff that I'm chomping at the bit to get involved, but it's not my firm's policy to take cases without an initial retainer. And in a case like this, especially if there's like a business valuation issue, like my retainers are high. So it's like, there isn't even a way for me to get my initial retainer. So then in order to take the case, I've got to go way out on a limb. Like literally by the time I get to a temporary orders hearing to ask for temporary fees to get some of that money back, number one, I'm going to be so far in the hole, what my partner's heads are going to be spinning. I mean, we're talking about 3 months of work and heavy work to then hope to get paid. And then secondly, judges are not inclined to do temporary fees a lot of the time. I mean, even despite a big disparity in a cutoff of stream of income or sources of income, they don't do it like they should. And then three, even if they do it, it's not enough to cover my bill. So then, I've taken my swipe at it, I get a big hunk, but I'm still, the party's still in the hole, my client. And it's like, do I continue to go into the hole for another 5 months? So you're always just chasing. And, and a lot of firms won't do it. Sometimes I do it, but I just feel really bad for those people. And I just wish the judges would be a little bit more receptive to this idea of, like, and I forget what they used to call it. It's a war term when you strangle off all of the resources to get in and out. Like you can't get shipments of food or supply.
Right.
Into the army. That's a battle strategy because then it depletes.
Well, it's a battle strategy for this case, for divorce cases too, because it happens, and it's just there's such an unlevel playing field that when someone can depose people and someone can subpoena and someone can send out all kinds of discovery requests, and that costs so much money to go through it and to do it and collect it, and it's a lot. It's expensive. And remind me later after we get off of this, I want to talk to you about something that I heard of that, like, it's like a company that now does loans. They're divorce loans.
Yes.
And I talked to somebody about that. I'm going to have them on the show.
Oh, great.
But they will give somebody the, it's not, I don't think they get a ton, but I think they get like up to $10,000 or something to start their litigation. And I don't even know what the interest rates are. I'm sure they're probably ugly. But if that's something that could be useful to get them, in the door, to get the temporary orders to, then possibly that's something. But I am going to have them on the show because I think it's a great idea.
It's a great idea.
So how do you value things? So let's go back. Let's kind of back up to like valuing, and say somebody has to sell all their stuff to pay the utilities, but they sell their lawn furniture that was $10,000 lawn furniture they sell for $1,000. Are they going to get in trouble for selling it for 10% of what they paid for it, or is it just Craigslist value?
I mean, again, assuming that they were justified in selling it in light of the preliminary injunction for necessities or whatever. I mean, look, people, this never fails. People assume that their property, their tangible personal property, like household furnishings and that sort of thing, are worth way more than they are. And like, I can't tell you how many times, well, I just bought this 80-inch TV like 2 weeks ago for $4,000. I should at least get $3,500 out of them. Like, what world are you living in? Like, that's not how that works. So, I mean, granted, you could argue, like, look, if you took an asset and sold it to your brother for $5, that's different than I just took what I could get so that I could have money to pay my lawyer. There's a different analysis there, right? It's like, oh yeah, your brother $5, and then he gives it back to you after the divorce is final, that kind of crap. But if the judge is convinced that you're legitimately selling something to make make ends meet, and it's not way low ball and it's not just unrealistic, then I think you'll be fine. I mean, granted, you do want to try to get top dollar for your stuff so you can get the most money you can out of it. But I mean, if you had something that was worth $4,000, or you bought it for $4,000, you sold it for $1,000, I mean, I don't see a problem in that. And for the other side to be able to make, or at least prove, a valid claim for waste, let's say, at trial, they're going to have to spend the money to have that particular item appraised, or at least show some evidence as to what that item is worth. But I mean, really, I've heard judges say this, and I'm sure you have too, Launi. What would you get for it at a garage sale?
Right. Yeah, it's usually like Craigslist values, garage sale values. But what about stuff like, and I know I've had to do this before, and I've been out of the game for 5 years ago. Yesterday was my last trial.
Wow.
And
you have the anniversary documented,
Oh, it came up on my Facebook because it was a really great trial. I was really lucky. It was with Gloria, and it was an all-day trial, and it was such a fun trial. You know, sometimes you have the really fun trials where no
Yeah.
one's being jerks to each other. It's
Yeah.
just, you have different beliefs. And so you go in there and Gloria was in a wheelchair, and my daughter was my paralegal. And so she was helping Gloria with her exhibits too, which I'm
Oh.
sure judges just don't see often, but it was just a very kind kind of thing back and forth. And I would take up exhibits for her to her client, because I wasn't going to make her, you know, she's a friend of mine. I wasn't going to make her
Sure.
wheel herself up to there trying to hold on to exhibits that likely would fall out of her lap. So yeah. So anyway, what I did, you know, there's things with like guns.
Yeah.
You know, how do you price those? Because those, you know, those used guns can go up in value like right now. You know, whenever there's a scare of a you know, guns being taken away, all of a sudden everyone's buying guns and ammo doubles. And so what do you do for that?
Well, I mean, kind of my advice on this is it's not related to which side I'm on. I mean, it applies to both sides, and it's get it valued. So typically what I'll say is like, do you have anything that's a collectible in nature that's worth over $1,500? Okay, yes, I've got XYZ. And it's like, okay, then maybe we need to get a value. So a big one I had recently was baseball cards. Literally, my client had some memorabilia and baseball cards that were in a vault in Oregon, and there was appraisals on them. They were locked up. And I'm like, yeah, let's get those valued. I mean, you know, or, you know, my client's spouse wanted them valued. And I'm like, yeah, that makes sense. Let's do that, because this is going to be a substantial thing. Guns, ammo, that's another one. That's huge. Stamps, coins, you know, even like gold, silver, all those sorts of things. You want to get that valued based on market price for those items. So, I mean, you have to do the cost benefit analysis, right, Launi? I mean, you have to look your client in the eye and be like, is it worth spending $1,000 to have $1,500 worth of stuff valued?
And
Like,
I think, do you ever just have them go online and go, okay, I want to buy a, you know, a Ruger, whatever, or a, you know,
yeah,
whatever. Like Steve has like his FBI weapon when he was in the FBI. You know, it's an old weapon, but it's worth something. So I think you can go online and actually find that weapon and what the value would be in the case and all that stuff. Do you do that too?
yeah, I always have them do that. My only problem with that, I mean, that's good for mediation, settlement, that sort of thing. But at trial, like, I mean, if we're going to pack up our stuff, drive down or sit in our office virtually, or preferably drive down and put on a case, we might as well have an appraisal, because that's the gold standard, of course.
Right.
But yeah, sure. Like, we're not trying to go to trial. Let's mediate, let's settle, and it'll give you a good baseline. I mean, I had a case where there were the couple, particularly the husband, used vehicles as his retirement. Like, so we acquired like 70 vehicles.
Oh.
So you know, the way to value vehicles would be to look at Kelley Blue Book or have an appraisal done on those as well. And he started selling off a bunch of them during the litigation. And it's like, I mean, it's a cumbersome job. And firearms, another, like, some people literally have 150 firearms.
Right.
And say two gun safes, and they're locked and we can't get into them. And so then there's this issue of getting access to the items to inventory them. That's a big issue that we sometimes fight about if the other side is resistant. And then, you know, inventorying them and then valuing them. But like you made the point of, well, just go online and try to find a similar, like, some of these firearms are like 1885 muzzleloader from the Civil War. Like, there ain't nothing online that's going to be comparable. Like, you're going to have it, somebody come look at it from an auction house or somewhere that can say, look, and, you know, obviously the spouse that didn't own the property or didn't have possession of the property is like, well, that's a special gun. It's got a special butt on it, or, you know,
it's worth way more.
It's way more, right? So then it's like, all right, well, let's find out. Let's get it appraised.
This actually is a good time to do a quick public service announcement. If your spouse or you or whoever has collectible items, take pictures before you leave that house. Take pictures of whatever you can take. Take pictures of the sales receipts. Take pictures of what's in the safe. Take pictures of the ammunition. Take pictures of whatever you can get, because yeah, you might get in there to view the safe, but half of the crap might be gone by then.
Wow,
And
that's a great nugget. Like everybody should listen to what you just said because we could do a whole segment on divorce planning stuff, and maybe you've already done that. But like one of the first things I do, take photographs, document, go into the file cabinet, get into the computer, get everything you can because as soon as that other side is served, poof, stuff disappears. And in fact, I had this recently where I've been consulting with this client for like 8 months now, and we haven't filed for divorce. It is imminent. There is some violence going on. But for 8 months, she's been very methodically, taking photographs and logging firearms, serial numbers.
yeah,
There's hundreds. So it's like, we've already started compiling the list. That way, we're not spending 3 months during the litigation figuring this out. We can literally just send that list to an appraiser or a guns dealer or, somebody of that caliber, no pun intended, and have them value it, or at least give us a sense on what it's worth. Because everybody will say, that gun's $100. Sure.
yeah, sure. And you have, the ones that they're saying there are 100 that, might really be 100. And then you have the ones that are 100 that might be 5,000. You just don't know. At least I'm not a gun expert. So I don't know, but I do know to take pictures and to serial numbers, any information you can get it. Same with the house. Now, let's talk houses, because valuing houses, everyone's like, well, I mean, and I know you've done this too, you've gone into, as a mediator, maybe you have people come in and they haven't, no one's got a value of the house. Somebody says, well, I think it's worth $1 million. And somebody else says, I think it's worth 500,000. And you're like, all right, well, Zillow says it's worth 650,000. But that realtor.com or whatever says it's worth, 700,000. How do you typically value? I know courts take Zillow. I know that they will if that's all they've got, because they've got no other choice, right?
Yeah, you got nothing else to use. In the court, I think it's a little bit unethical for a judge to go do their own private investigation. So even if the judge is on their computer in their office as they're typing up the ruling and looks on Zillow, I think that would be ethically
right, for sure. But oftentimes people come there with a Zillow estimate printed out, right?
Like, look at this. Oh my gosh. I mean, sometimes I'll get these cases on the back end and I'm like, oh my gosh. Obviously an appraisal is the gold standard. So to answer your question, like, what do you do to value? It depends on where you are in the case. Client comes in, you're getting initial intake information. You're just trying to get a sense on how much equity is in the house, if any. Go on Zillow. And sometimes I'll put it as a part of my initial disclosure. Here's the Zillow. But you can't rely on it. You most certainly can't rely on tax assessor's documents or opinions of value, because those are way, way off. Like that, I wouldn't even use that for a preliminary assessment. Even though it says on there, you get it every year and it says fair market value of your house. And you're like, what? That's
not... those are only, I became a realtor while I've had my little hiatus. Nice. And so those are only allowed to increase so much every year. And that's why they're so off, which I found out in my real estate class. Yeah. But what about a broker's analysis?
Yeah, so I love brokers' opinions or calculation of values or whatever you want to call them. So there's obviously your gold standards, the appraisal. The kind of baseline would be Open Door, Zillow, one of these types of things. A step up might be comps, where it's just a realtor pulling together comparable sales in the area, and then, hey, here's kind of this general idea on what the value is. I mean, that's helpful, but again, not something I typically like to rely on. Plus, you get into the argument, well, these are all 4-bedroom houses, I have 5 bedrooms, or like my house, I've had it appraised before. It's just a unique layout and all of that. So when I went to get it appraised for a refinance, I mean, they couldn't find a comp. So they were pulling comps that weren't really related. And if you really cross-examined that realtor, you would find out that this estimated value is just pie. It's just a pie in the sky. It's like, it's not based on anything. So then you get a little bit more elevated with these brokers' opinions, whereas there's a lot more assessment. And I like these because they're cheaper. If you find a really good realtor, they're going to do them for free for your clients.
My
Probably.
my husband's son does them for us for free.
So, I mean, you get them for free. And, the hope is that on the back end that they'll be the realtor that you use to
Right.
sell
At some
that
point,
property.
right? Yeah.
Frankly, that has quite, just between us, hopefully no realtors are watching, but it has quite the opposite effect because, if we're disclosing an opinion of value, a broker's opinion, and that person's
Right.
name is on it, the other side is never then going to agree to use that realtor.
Right.
They think it's more of like a networking thing where it's like,
Yeah.
you'll use me in another case or whatever.
Yeah.
But those are really solid and I like those. But again, appraisals are the gold standard, and it's, you want to be critical of appraisals as well, just to make sure that, they're, on the right track or they used similar comparable properties. But I like to be able to look at an appraisal and just know that there's a lot of faith in that number. But, sometimes in today's market, you'll do an appraisal, you get to mediation 3 months later, and it's like, that appraisal is not accurate anymore.
Right.
I mean, there could be a big difference. So then you're always kind of playing this guessing game, but I guess the idea is to get as close as possible to make it as fair as possible.
Yeah, I agree. I think that's really all you can do. Well, I think that's kind of all I had for you today. Is there anything you'd like to add about, getting values or temporary orders on property?
No, I mean, I will say this. It's so frustrating. I'm a private mediator and also the judge pro tem, and I've been doing monthly settlement conferences once a month for the last 6-7 years. I cannot stand it. And now parties are required to avow that discovery is complete.
Right.
You even get to ADR. And I assume that the same to be true when you're paying a private mediator, that you're not going to go there and not be ready. But it happens still a ton where people show up and they're like, well, we don't know what to do with the house because we don't know what it's worth.
Yeah,
So-
I had Annette Burns on the other day, and she was preparing for mediation. We had that same conversation. It's like, how are people going in? So they still do. They're still going in completely unprepared. And
So my advice, I guess, would be if it's a big enough issue for you, get it valued early. It should be one of kind of the first things you're doing as a lawyer is trying to think about, okay, let's get the ball rolling on some of this stuff. And as a client, you need to be insisting that your attorney not just sit back and wait, let's get it valued so that we know. But other than, and by the way, pretty much anything can be valued. You can hire an expert to value anything. You can hire an expert to value a pension, even though it's not a defined amount that you know about. I mean, you can get actuarial, there's all kinds of things that you can get valued. So do it. And there's a lot of resources out there to where you can get it done in a cost-effective way. So, push your attorney to do that so that you're in a good position to settle when you get to mediation.
all right. Well, thank you so much for being here. I appreciate it. As usual, I will have Kaine's information below on the YouTube and on the podcast. So if you have any questions for Kaine, feel free to reach out to him too. Thank you, Kaine.
Launi, this is awesome. You're doing great work.
Thanks.